Case. Appeal number 126348, State of Kansas versus Ricky L. Hollins, Sedgwick County, briefs both sides.
May it please the court, Corey Call, appellate defender representing Ricky Hollins, present, ready for argument.
May it please the court, Assistant District Attorney Matt Maloney for the state, present and ready for argument.
Yeah, Your Honor, that concludes the morning docket.
Thank you. Counsel? You call whenever you're, Mr. Maloney gets started. It looks like you're ready.
May it please the court, counsel, I would request 3 minutes for rebuttal.
3 minutes is granted.
Thank you very much. Mr. Hollins was convicted of first-degree murder in Sedgwick County, and we raised 3 issues: a judicial comment error issue, an instructional issue on a non-pick premeditation, and then a cumulative error. And I would just note that I think the state would agree that we objected to both of those, and so they would both be included in the cumulative error analysis. The first issue, they had the trial, and the case went to the jury. And after about an hour, the jury sent out a question. And while that was going on, 2 jurors approached the assistant court and said that one of the jurors was not participating in deliberations. And what that apparently meant, they were fleshed out that he would vote. He expressed an opinion, but he would not engage in discussions about the reasons for his vote or the facts. This was his vote. And so he said, well, what are we going to do about that? And the judge says, well, I think I should tell them that the jurors are required to discuss the facts. And the defense counsel says, I don't think that's a good idea. It's only been an hour. First of all, the jury foreman is supposed to bring the question out. We don't know if this is a problem the jury has, but we should do nothing. Let's just see how this plays out. But nonetheless, the judge did instruct the jurors that jury deliberation process requires a discussion among your fellow jury members related to the facts and the law. And that was improper because the district courts are not allowed to enter into the sanctity of the jury room and tell juries how to deliberate. I guess I'll start saying that I think there are 2 problems with this. One is substantive, and the other is the timing of it. So substantively, telling the jurors that they have to discuss the law, that they have to discuss the facts, is improperly imposing on them a duty that doesn't exist for jurors. And it goes back to the right to a trial by jury and the sanctity of the jury room. We don't get into the black box of the jury room. The second problem with that is the timing of it. And we've talked about, this court has discussed a hammer instruction, Allen charged with sometimes they have to say, we want you to consider when the jury is deadlocked that they need to try and do their best to conscientiously reach a verdict. But this court has been pretty firm that you can only do that if you have given that instruction prior to deliberations, because what we don't want is for the jurors who may be holding out or jurors who are feel a certain way to feel coerced by the court, that the court is talking to them, that the court wants them, that the right thing to do is to vote in a certain way. And that's what happened here. You had the state tries to say that this didn't single out any juror, but this jury, the judge did not say juror number 9, you need to talk to everybody else. But from the facts, it appears as though everybody knew that it was juror number 9 who wasn't discussing the law and the facts. So when the judge says you need to discuss the law and the facts, he's talking to juror number 9. Juror number 9 knew it. All the other jurors knew it. And it could certainly be coercive on juror number 9. I think the big issue here is harmless error. And one of the questions, kind of surprisingly to me, is who bears the burden of proving that whether the error was harmless or not harmless. And as I said, I think it's the record is clear and the state sees that we objected to this, to the judge making this comment. And in those situations, the state bears the burden of proving that the error was harmless. And the state tries to say that one of the problems the state will have is that there's not a lot of information about what exactly happened in the jury room, in large part because we don't get into the jury. We don't get into those discussions. So there's not a lot of discussion about that or facts about that. And so the state argues that the defendant has the burden of designating a record on appeal. And that's true. We do have the burden of designating a record, but that language has always been used that the appellant, the party seeking reversal, has to point out in the record where the error is in the record. That we have a burden to designate a record doesn't impose on us an evidentiary burden in the district court to establish that the error was harmless. If when it goes to motion for new trial, there's an error, the district court found it was error, the state still has to prove that that error was harmless. And if they want to put all their eggs down below in the it's not error basket, that's fine. But it makes it very difficult then, but they haven't met their evidentiary burden to prove that it was harmless beyond a reasonable doubt.
Is there any case law on what deliberation actually is?
I wasn't able to find much. And honestly, we've been around for a long time. And there's sort of, I think it's telling that there's not a lot of cases where judges talk to jurors about how to deliberate and what's proper and what's not proper, because it depends on the jury. But I was able to cite to a couple of California cases, which I think were instructive, that talked about the sanctity of the jury and that it's part of the right of the juror, the right to a jury trial is that the jury, we don't get into what is involved. I guess we also have the oath.
What if a jury, this is just a hypothetical,
Yeah.
after a verdict, guilty or not guilty, let's just say it's a guilty verdict, the jury all unanimously tells the defense lawyer, we did not deliberate. Would you then, as a defense counsel, have an argument that the verdict of guilty was tainted in some fashion?
I think so.
Why?
Well, because I think I'd have to go back to the oath.
Is it because deliberation is required?
It is. And the question then is deliberation require discussion of the facts and law among the juries? Or is it deliberation that the jury has to go in and make a conscious choice of listen to the evidence, and then they have to make the decision of whether to do it or not?
Wouldn't we look to ordinary definitions of the word deliberation, assuming for purposes of the question that it's legally required?
Right. I think that's right. I mean, we started to do it with statutes. The oath requires that a jury swear or affirm to try the case conscientiously and return a verdict according to the law and the evidence.
Doesn't say anything about
It
deliberation.
doesn't say anything about deliberations. I mean, you have conscientiously, but that seems to also be maybe a personal thing that you have to conscientiously, which is, I think, is what we talk about. Go back to the Allen charge that talks about you have to make your choice. You have to,
Again, you could imagine a jury that got together and just said, we're all busy. We don't have time for this. Everybody probably already has your own mind made up. Let's just vote.
oh,
We're not gonna do it.
yeah, I can, but I don't think that's, I think that happens all the time.
But
You
you
have-
earlier said that was inappropriate.
Well, that was, you said deliberations, and if they said,
No deliberations.
well, I mean, if you're using deliberations synonymously with discussions, then I disagree with the answer, because I do think deliberations, and I think the Bowers Court in California talked about that, the difference between deliberating and discussing. But then I don't
What
think,
is your definition of deliberate?
I think they have to gather in the room, and I think they have to vote. And I think that
How would they reach a verdict any other way other than voting?
right, yeah, I think that's,
So you're just making a circular argument that a verdict ipso facto means they did deliberate.
Right, but
Okay.
I guess, so if we go back to, I don't want to get too etymological, but if we go back to a deliberation, to be deliberate, that they have to take, there has to be a process by which the jury reaches a verdict. They have to go back and they have to decide the case, and deliberate, I think, means decide the case. I don't know that it has to be that they have to discuss the law or discuss if, I mean,
That's the heart of this question. That's the heart of this case, I mean, is are individual jurors obligated to interact with other jurors or not? Isn't that the heart of the case?
I think that's exactly the heart of the case. Yes, and I think,
That's what I'm trying to
right, and it's
discuss with you.
right, and I understand that, and it's difficult because obviously that's what we want, right? I mean, the best case scenario.
Well, I don't know if I would put it in terms of what I want. I would put it in terms of what does the law require?
That's
Does the
exactly
law
right. Yes.
require jurors to interact with one another or not?
Right, and I guess there's certainly nothing in the oath that requires them to interact together. There is in the nature of it, we're asking them to decide the case, and as they're doing it as a collective. But do they have to interact with each other? I don't know where that would come from. That they have to interact. They have to.
It would come from this rule about deliberation, and deliberation as at least a common definition includes interaction.
Right, and I guess that kind of goes back to, well, where is that rule that we talk about?
That's what I started asking.
That's right. We talk about that jurors deliberate, and we talk about, because that's the common course, and we talk about that they have to. We talk about jury deliberations in the terms, but as far as a right to a jury, you have 12 people. That's what's required, right? Or not 12, but you have a jury, and they have to decide the case. And I don't know that there's anything or where the rule would be, or I haven't been able to find anything even going back to the common law, other than you don't stick your nose in the jury's business. That kind of goes back. And even if that's true, let's say there is a requirement that it's true, I still think you have a problem akin to the Allen charge from the timing of it. If we want to tell jurors beforehand, okay, you have to deliberate.
Your time's running out.
Oh,
I'm sorry. I'll just interrupt.
Yeah, please.
I know that's
Yeah.
rude. I'm sorry. But I want to read for you something from the 10th Circuit, which of course is not binding on Kansas law, but just get your take on it. The 10th Circuit has said that the very object of the jury system is to secure unanimity by a comparison of views and arguments among the jurors themselves. And this is only achievable if individual jurors will listen to the arguments of other jurors. Do you think that, I mean, I'm guessing, I think I know your answer to this, but should we adopt this as the law of Kansas, or disagree with this?
Well, I guess, one, I disagree with that, because I think the key is in the voting, not in the talking. But even that talked about the duty of the juror was in the listening and the comparison of views,
So I
as opposed to the expression of a view. Go ahead. Sorry.
just offer to you that this strikes me as a rule that would generally be favorable to defendants.
Well, yeah, and civil parties, I think, if they can find a juror that didn't talk during deliberations, and or that jurors can be removed, but mostly you go after the fact. You go in and say, yeah, the juror number 12 didn't say anything. They just voted aye. Well, did they violate their duty because they didn't discuss, even though they agreed with everybody? You may be right.
I just want to clarify that you're asking us to adopt a prosecution favorable rule.
Yeah, it's a Mr. Hollins favorable rule.
Right.
And it may be, we don't know. But yes, that's the rule I'm asking you to adopt.
Can you clarify quickly for the record, the statements that you object to from the district court judge came at the end of an actual response to a jury question that was submitted?
Yes.
Yes. And some of that language, I notice, really does sort of track the language of the oath itself. There's some differences, but there are similarities too. It just seems to me like I'm not so sure that a juror would have felt called out by that language, given the totality of the circumstances. Tell me where that thinking might be off base.
Well, we don't know because the record's not very clear, but I think one way that presumably that there was some sort of discussion in the jury room with juror number 9, that you are not doing this. And so one is that if there's a discussion where you're not talking to us, we want to know what I don't think there's any pressure by the juror. They generally, let us know, what's your vote? But why are you voting that way? And he's like, I'm not going to say. I'm going to say. There's one judge, and then they complain to the judge or the court, and then the court gives that instruction. When they go back, I think the juror is going to think they're talking to him. And I think the other 2 jurors who complained are going to go back and say, see, he said, you got to tell us, you got to talk to us. So I think in that sense,
Sort of speculative, but maybe that's your point in terms of harmlessness, that,
Yeah.
and it's not our burden.
that's right. I think, yeah. And also, I think that was the judge's point. We can't know from a cold record exactly how it came across or whatnot, but we know the intent of the judge when he said that was to get juror number 9 to talk to the other jurors. That was his intent. And so I think, I don't know if people picked up on that or not, but I think it's always sitting up here in the appellate courts trying to figure out, well, what happened below? If you look, what were they intending to do? That can come across in a lot of different ways. Thank you.
Thank you. Mr. Maloney?
May it please the court and counsel, Assistant District Attorney Matt Maloney for the state. With respect to issue 1, I guess, first of all, as I worked on this brief, and again, as I prepared for the oral argument, I think the one word that kept coming to my mind in looking at this comment from the court, before even getting into the technicalities of the definition of deliberate and whether it was legally appropriate, but the word that kept coming to mind is innocuous. I just have a hard time. Sometimes I think as attorneys we'll latch on to something and we'll assign this great significance to something that in the eyes of the jurors likely would have had little, if any, real effect, let alone something so significant that it would have actually affected the verdict. This is a situation where a couple jurors brought this matter to the administrative assistant's attention. The judge did not even speak to those 2 jurors directly, let alone bring the other jurors into the courtroom to discuss this matter, let alone single out the juror who was the alleged source of the issue. But instead, at the end of answering a jury question that had been asked, simply said that he wanted to remind the jury that the deliberation process requires a discussion among your fellow jury members related to the facts and the law. So I think before we get too caught up on the technicalities, we just need to keep in mind the nature of what happened here. I agree with counsel. I certainly did not find any case law, Kansas case law, remotely on point with respect to this particular type of comment. But when you look at what the defense was relying on in their brief, it was primarily these 2 California cases. And those can be very clearly distinguished. In Engelman, you had a situation where an instruction given by the court obligated the jurors to report any fellow juror who was not participating. So very clearly that intrudes on the process by enlisting your fellow jurors as essentially referees to police the way you're doing things. And that was what was found problematic. Although I would note that there was no reversal in that case. It simply said from this point forward, that instruction should not be given. But I think what's equally important about Engelman is that in that very case, there was another instruction that was given that informed the jurors to discuss the evidence and the instructions with their fellow jurors. And that instruction was not even so the Supreme Court in California didn't even so much bat an eye at that instruction. So even within one of the cases that the defense is relying on, an instruction that was very similar to what the court orally instructed here was not found to be problematic. And then in Bowers, the other case that he cites from California, you had a situation where the court actually discharged a juror for not actively participating. And he did that after discussing and questioning the issue with each individual juror. Suffice it to say, here we don't have a situation where any juror was just discharged. No juror was questioned by the court. Certainly no juror was singled out. This was, again, an innocuous comment that the court made. Probably took about 5 seconds to make this statement. And I do want to circle back to the beginning of this process, because the defendant is arguing that this is judicial comment error. And I think when you look at the argument as a whole, it's clear why he wants that standard to apply. Because if he can get this to be considered judicial comment error, then he can put the burden on the state to say that we have to affirmatively show that there was no prejudice, as opposed to if it's simply a jury instruction error, then the burden would be on the defendant. And Boothby is the case that talks about judicial comment error. And it says that it applies to, quote, erroneous judicial comment made in front of the jury that is not a jury instruction or a legal ruling. I have a hard time understanding what this is if it's not an oral instruction. The court was telling the jurors how to do something as part of the deliberation process. It wasn't in written form, but certainly that doesn't mean that it's not an instruction. It's an oral instruction, and I compare it on page 11 of my brief to Struzik, a case that also involved an oral statement that the court gave to the jury during deliberations. And in that case, this court did treat it as an instructional issue. And so our position is that this court should analyze it as a jury instruction error, and that definitely does affect then the standard of review, and especially when you get to the issue of whether any error that occurred was harmless. And that's the point in my brief that I'm making, that the defendant is essentially saying, yeah, we know that the record doesn't contain a lot of info about this, because nobody asked the court to bring any of the jurors into the courtroom to get into any more detail about what exactly was happening, what juror number 9 was or was not doing. And so the defense is basically saying, well, we don't know really what happened here, even though he didn't ask for any additional information. And he's asking this court to reverse a first-degree murder conviction based purely on what he labels himself a thin record. And again, because this is a jury instruction issue, it should not be looked at as the state having to conclusively show that this did not affect the verdict. The burden should be on the defendant here, and by his own admission, it's a thin record. And I would submit that this court should never reverse any conviction, let alone a first-degree murder conviction, when the defendant has failed to designate a record that shows that this had any impact on the actual verdict. I think that my brief addresses the remaining arguments that I have on this issue. But again, our position is that the defendant has not shown, A, that this is error. There is no Kansas case law that would support his argument. The foreign cases that he has cited are, A, distinguishable, and B, I think actually cut against his position, because again, that Engelman case included an instruction very similar to this, and the Supreme Court found no problem with that portion of the instruction. If there are no questions, Your Honors, I would submit the second issue, the Bernhardt premeditation instruction. I would submit that on the brief. I guess I actually would just very briefly note that just within the past month or so, this court decided State versus Zonker. And I don't know that it necessarily changed a ton, but it did clarify that the additional language from the Bernhardt instruction clarifies that the additional instruction is factually appropriate because it provides a temporal clarification, even in situations where there might not be evidence of a fight or a struggle. And so I think that's important here because this does show that these two people were in the motel room for a while. And so Zonker, I think, does expand a little bit upon Bernhardt and the other cases that followed. But I'd also, as a backup argument, I would argue that in this case, there was evidence that would support that there was some sort of a struggle between these two people. The victim suffered extensive injuries, blunt force injuries, and the evidence also showed that the defendant got maced during the course of whatever happened in this motel room. So I would submit that even had Zonker not come down, even if we were just going under the previous case law on this issue, that this instruction was factually warranted based on the evidence that was submitted at trial. If there are no questions, our position is that there was no error in this case and that the defendant's conviction should be affirmed.
Any discussion? Thank you.
May it please the court, I would just, Mr. Miller and I have a fundamental disagreement, I guess, on the standard of review if the defendant objects to an instruction. It's my understanding that if the defendant objects to an instruction, and it is found to be error, that the state bears the burden of proving that the error was harmless. That's what I understand. And I understood him to say the opposite of that, and I don't believe that to be the case. Unless this court has any questions. Thank you.
All right, thank you. Thank you to both of you for your arguments this morning. The court will take this matter under advisement.